The Honorable Chief Justice and Associate Justices of the Supreme Court of North Carolina. Oh yes, oh yes, oh yes, the Supreme Court of North Carolina has resumed sitting for the dispatch of business. God save the state and this honorable court.
Good afternoon. Our next case is State versus Johnson, and we will hear from the appellant.
May it please the court.
Excuse me, let me just quickly say that Justice Berger is recused in this case. Thank you. Sorry.
May it please the court. My name is Marilyn Ozer. I practice in Orange County. I'm here this afternoon representing Mr. Dmarlo Johnson in his direct appeal of a first-degree murder conviction out of Durham County. This afternoon, I would like to reserve 10 minutes for rebuttal. In the trial court, there was only one issue for the jury. What was Mr. Johnson's state of mind at the time he committed the acts? Similarly, there's only one issue for this court. Whether this court agrees or disagrees with Chief Judge Stroud's dissenting opinion, in which she found that no lawyer of any level of competence could listen to the approximately 3.5 hours of phone calls, and certainly not all 90 to 140 hours of calls during a 15-day murder trial, then do any needed investigation based on the calls, discuss the relevance of the particular calls with expert witnesses to prepare for rebuttal evidence. There are not enough hours in the day, and even competent counsel must sleep occasionally. Prejudice must be presumed because there was no likelihood defendant's counsel could provide effective assistance. Chief Judge Stroud, of course, was depending on United States v. Chronic, 466 U.S. 648, and State v. Rogers, an opinion of this court, 352 NC 119 in 2000. State v. Rogers explained that while a defendant ordinarily bears the burden of showing ineffective assistance of counsel, prejudice is presumed without inquiry into the actual conduct of the trial and the likelihood that any lawyer, even a fully competent one, could provide effective assistance is remote. Rogers goes on then to explain what a court needs to do when it's reviewing this kind of error. And Rogers said the court should examine the surrounding circumstances to see whether they justify the presumption of ineffectiveness.
Ms. Ozer, I hate to interrupt you so early, but I want to make sure that I get my question in light of what you just said about that time frame being so limited, that while that's fresh on your mind, I wanted to be able to bring this up. Does it make any difference that the defendant's counsel had these telephone call messages and the words out of the conversations 8 days prior to the trial?
That's not exactly accurate. On page 5 of my reply brief, I've actually printed out a calendar because it's easier for me to actually see dates when they're printed out. The first CD was not given to the defendant until April 12th, which was a Wednesday. It had 335 calls on it. The next day, the prosecutor served a notice of hearsay. And then we had court holiday, because it was Good Friday, going through Easter Sunday. So it was not until Monday the 17th that the investigator tried to open the jailhouse calls that had been sent and couldn't do it because it was recorded on proprietary software. So it wasn't until the next day, April 18th, a Tuesday, which is less than a week before the trial begins, that they even had a copy of the CDs that they were able to open up. So when they did open them up, they saw this list of 335 calls with no dates, no explanation of what's what. So Steve Friedman, the defense counsel, emailed Mr. Dornfried and said, "Can you give me dates at least?" And he responded, At this time, I do not intend to use any of those calls, and I am no longer requesting anyone to continue listening to the calls. So this is less than a week before they're told, don't look at it, we're not looking at it, don't worry about it.
Did the defendant have the right to absolutely rely upon the state's representation at that time prior to trial without any testimony having unfolded as to perhaps impact the state's strategy along the way?
I don't think he had any choice. Mr. Dornfried is a respected member of the bar, officer of the court. This is in writing that he is no longer requesting anyone to continue limiting the calls. I can't imagine a situation in which a prosecutor you're familiar with told you something in writing and you decided, I can't believe this. And in any case, even if you're going to disbelieve an officer of the court, 335 phone calls would take days to listen to. We're a week before the trial begins. It would be ineffective assistance of counsel to stop interviewing witnesses and instead go sit and listen to days worth of jailhouse calls when the prosecutor has told you he's not going to use them. And along with these phone calls, they've been given a list of 45 witnesses. They've been told about 2 different hearsay witnesses, one of Mr. Saeed that they actually had to spend a couple of days finding. So, you know, in the real world, there are limits both to time and money and what you can do. You have to prioritize, and listening to phone calls that an officer of the court has told you he's not going to even listen to himself just would be ineffective, would be an irrational use of his time. Does that answer your question? The next.
Yes, thank you.
The next,
So the phone calls were used for rebuttal, correct?
that's right, Chief Justice.
And both the testimony of the expert for the defendant as well as the rebuttal evidence, both an expert as well as the phone calls, were used to establish that the defendant had the requisite state of mind with regard to premeditated first-degree murder, right?
Well, that's what Mr. Dornfried said he was going to use them for. What actually happens, which I find interesting, is when he calls his own expert, Dr. Laney, the phone calls are never mentioned. He doesn't ask Dr. Laney about the phone calls. So when she's through testifying, Mr. Dornfried tells the court that he's about to introduce the phone calls. And they have a long discussion about whether things can be redacted or not redacted. Then the phone calls are played with no testimony explaining them. And that's the end of the state's evidence. The way the prosecutor gets to saying it goes to a state of mind, as far as the jury is concerned, is not until the closing argument when Mr. Dornfried tells the jury, you listen to those calls, they show his ability to plan, they show his ability to count. And the problem with that is defendant has put on evidence, so he doesn't get the last closing argument. So the last information that comes before the jury is the prosecutor's interpretation of those phone calls, which I maintain is either incorrect or misleading. Because
it seems like the jury didn't believe the prosecutor. The jury found the defendant not guilty of murder based on premeditation and deliberation, correct?
they certainly did as far as the murder charge, but they did find him guilty of armed robbery and shooting at an officer.
And at least one of those is a general intent crime, correct?
That's correct. Shooting at an officer is a general intent crime. But
So the ultimate conviction was felony murder based on the 2 felonies that you have described.
That is correct. But Dr. Corvin explained to the jury that the combination of intellectual disability, bipolar, taking cocaine, which he called a dopamingeric, can't pronounce that correctly, but cocaine has the effect on someone who's bipolar to make them even more manic and psychotic, plus alcohol. And Dr. Corvin said at that point, the person can act, but he can't think. The acts are, he's using his cerebellum, the brainstem, rather than any ability to think. So while it looks like he's planning or intentionally shooting at an officer, he's not thinking. That, at least, is what Dr. Corvin told the jury. So I don't see how you can find beyond a reasonable doubt that hearing these phone calls is the very last piece of evidence that these jurors heard.
Well,
Didn't have an effect.
let me ask the question in a different way. I mean, we've got basically the way the trial court's judgments were entered. We had one judgment based on a conviction for felony on a first degree murder on the basis of felony murder using assault on a governmental official as predicate felony. That's one. And then the trial court separately sentenced Mr. Johnson for robbery with a dangerous weapon. Is that right? As a matter of fact.
I don't think it should be right because I thought one of them was arrested.
Well, I mean, that's what I'm thinking is the ultimate judgment that was entered in the murder case was based on the assault upon a governmental official, right?
Correct.
So basically the issue is, as the Chief Justice indicated, it looks like this court held in State versus Page that assault on a governmental official was a general intent crime.
Correct.
If that's the case, then how is the mental condition of Mr. Johnson relevant to that conviction, given that there's no requirement of proving a specific intent?
I don't think general intent means that you can operate without a brain. You breathe, you react to pain without thinking. And if you accept what Dr. Corvin told the jury, Mr. Johnson was not capable of thinking. It was more the involuntary type of action that an animal would have.
Was there any request for an instruction on insanity, automatism, anything other than lack of specific intent?
Well, there was the defense of mental illness, but no insanity defense, no. There was no notice of an insanity claim. But if you look at the video and you watch Mr. Johnson shooting the clerk and loading up the car, I mean, you have to wonder, the jury is obviously accepting Dr. Corvin for the first-degree murder, which is, quite an achievement for Dr. Corvin and the defense attorney. But they don't make the same judgment for the robbery and the shooting at an officer. So one has to wonder if maybe this was some sort of compromise verdict, that some of these jurors were going to hold out for everything not guilty, and some of them wanted everything guilty. So that's why, even if you're not in the Chronic and Rogers world, in which you don't look at the facts of the case, it's just presumed prejudice, it's a constitutional error. So the state is required to show beyond a reasonable doubt that this had no impact on the jury. And I don't think they can show that. Just because this was a jury that was willing, at least for one of the charges, to accept Dr. Corvin's testimony.
Well, it seems to me that they did not find premeditation and deliberation, which
Correct.
suggests that they were not persuaded that there was premeditation, deliberation, specific intent to kill.
That's correct.
But they did find him guilty of felony murder, at least on the basis of assault on a governmental official, which does not require proof of any specific intent.
No,
And I guess the thing I'm wanting some help on understanding is if there is no intent-based defense offered to assault on a deadly weapon with a governmental official, in that there's no insanity instruction, no automatism instruction, lack of specific intent doesn't apply.
but
Where-
there's
where
general intent, but
Can you cite me legally something that says that what you described earlier constitutes a defense to assault on a governmental official?
no, I think you're right that you would have to say he was blacked out, then that would be a defense. But
But does the any success with which the state had in attacking Dr. Porter's testimony using these calls have anything to do with a recognized defense to assault on the governmental official?
I think it does, because I'm just going back to he couldn't think. And the other thing about these jury calls, I don't know if any of you have listened to them, they are disgusting. The jury is not going to like this young man when they hear him yelling at his mother, yelling at his girlfriend, being totally irrational. There are 2 calls that are phone sex. And believe me, it's hard to listen to. The jury listens to the phone sex. And the state's explanation for that is, well, we just didn't have time to figure out what the words were in the call, when they were saying this, so we couldn't moot it. So the jury is not going to be happy with this young man, and they might be persuaded not to believe Dr. Corvin, not because these phone calls show that he's not psychotic, but because of his attitude to his mother and his girlfriend. And you have to take that into consideration. But in any case, if we're talking about Chronic and Rogers, the details of the case don't apply. Prejudice is presumed, no matter what. And in this case, I would argue that there is no way Steve Friedman could have listened to those calls, sent them to Dr. Corvin, discussed with Dr. Corvin what to do in Sir rebuttal, and get Dr. Corvin back to testify. It just couldn't be done. And if he had been able to do that, and what Chief Judge Stroud points out is that it would have been from the beginning of trial that defense counsel would have used what Dr. Corvin would have told him about the calls in jury selection, in opening, in cross-examining witnesses. So it's the entire trial that was impacted by his inability to listen to these calls. And Chief Justice Stroud pointed out in State v. Barlow, what you need to do is go through 4 different factors to decide whether or not a motion to continue should have been granted. The first one, the diligence of the defendant in preparation. I think there's no question that when you don't find out till the night before trial, you've been as diligent as you can be. The detail and effort with which the defendant communicates to the court the expected evidence. There was a lengthy hearing. The court and Mr. Friedman explained exactly what he had been doing all week, why he didn't have time, and what the limitations were. The materiality of the expected evidence. This went directly to the only defense, the defendant's state of mind at the time of the crime. And the gravity of the harm defendant might suffer. Again, the gravity is clear on its face. It went to the only defense the defendant had, his state of mind. And I think I'm down to my 10 minutes. So I would ask this court to agree with Chief Justice Stroud that it's chronic error, prejudice is presumed, and grant Mr. Johnson a new trial.
Thank you, counsel. We'll hear from the appellee.
Thank you. Good afternoon, Mr. Chief Justice, Your Honors, and may it please the court. My name is Zachary Dunn, here on behalf of the state in this matter. As both the majority and the dissent at the Court of Appeals recognize, there's no dispute that Mr. Johnson robbed and murdered Amir Mahmood and assaulted a law enforcement officer while unsuccessfully attempting to evade arrest. And as the discussion today has shown, the question before Your Honors is quite narrow. It's whether Judge Holt both erred and prejudiced the defense when she denied defense counsel's request for a continuance to have additional time to review audio recordings, a portion of which the state then used some 2 weeks later to rebut Mr. Johnson's argument that he had a diminished capacity when he committed his crimes. For at least two reasons, the Court of Appeals correctly held that the trial court did not err, and this court should affirm. I'd like to begin, if I might, with what the state believes is the threshold question and one that might be dispositive here, which is whether a diminished capacity defense was available for defendant's first-degree murder conviction under the felony murder rule when the underlying felony was a general intent crime. As Justice Ervin was discussing with Ms. Ozer a little bit earlier before, the record clearly shows on record page 66 that the defendant was convicted under on the basis of felony murder with two underlying theories, that being assault on a law enforcement officer and robbery with a dangerous weapon. And they specifically declined to find the defendant guilty based on premeditation and deliberation. So the state's main contention here, the main submission, is that any error in denying defendant's motion to continue was harmless beyond a reasonable doubt because the defense of diminished capacity is unavailable for a general intent crime, such as assault on a law enforcement officer. As Your Honor, Justice Ervin mentioned, State versus Page talks about, well, specifically holds that assault on a law enforcement officer or a government official is a general intent crime, and that the intent there need not be any intent beyond the intent to commit the unlawful act, and this will be inferred or presumed from the act itself. And here, of course, there's no argument that.
Mr. Dunn, what about robbery with a dangerous weapon? It is a specific intent crime, isn't it?
I'm sorry, what about robbery? I missed the last part of your question.
Robbery with a dangerous weapon is a specific intent crime, isn't it? Don't you have to prove the intent to steal, take, and carry away the property of another?
That's right. And that's why it makes sense that the state wanted to introduce this evidence to show a lack of diminished capacity. At the time that they introduced the evidence, the state was attempting to have defendant convicted both of murder based on premeditation and deliberation and on armed robbery. But they were also attempting to have him convicted, and he eventually was, on a theory of felony murder with the underlying felony being a general intent crime. So even if, assuming, arguendo that there was some error, which I'll discuss a little bit later why it's our position that there was not, but even if there was some error in not allowing additional time to come up with rebuttal evidence regarding diminished capacity, that diminished capacity evidence, all of it, was irrelevant to the conviction based on the general intent crime, which underlied one of the felony murder convictions. So
the defendant was separately convicted and sentenced for robbery with a dangerous weapon. The Page non-prejudice argument doesn't have anything to do with whether defendant's chances for a more favorable outcome as to the robbery with a dangerous weapon conviction or prejudice, does it?
I don't think so, but Your Honor, defendant only received one life sentence for one murder. So whether
the court, I don't have the record in front of me, but the Court of Appeals decision says on page 4, quote, the trial court sentenced defendant to life without parole on the murder conviction into a term of years on the robbery conviction to run consecutively with his life sentence.
That's right, Your Honor. But I think the main point here is that even if defendant should have been given additional time to come up with some evidence about this diminished capacity a defense, the error was harmless because he still would have been convicted on the felony murder with the underlying.
How is it harmless with respect to the separate conviction for which he was separately sentenced to a consecutive term for robbery with a dangerous weapon?
I mean, I think our argument would be that it's run consecutively, but I can certainly jump into why we think that there was no error, because I don't think that there was.
Before you do that, do talk to me about one other thing. Ms. Ozer, in her discussion with me, pointed to the fact that, at least under United States versus Chronic, to the extent that you have a violation of the right to assistance of counsel under circumstances when no counsel could provide effective assistance, no showing of prejudice is required. I mean, what's your response to that argument?
I think that leads perfectly right into my next argument, so thank you, Your Honor. I think that the standard here, which is set by this court in Branch, 1982 case, but many subsequent cases, is that the denial of a motion to continue. Remember, this is not an IAC argument. This is, the denial of a motion to continue. I understand that IAC is part of it.
I think the argument is that it was a constitutional violation to deny the motion to continue because the effect of that decision was to result in a deprivation of the right to the effective assistance of counsel. I think that's the argument.
I think, yes, I believe that that's the argument as well. And this court has held that the denial of a motion to continue, even when the motion raises a constitutional issue, is grounds for a new trial only upon a showing by the defendant that the denial was erroneous and also that his case was prejudiced as a result of the error. Again, that comes from State versus Branch, case from this court. So I think that that is the standard that controls here. Both.
Well, let's look at, you certainly are correct in reading that from Branch, and this is one thing I was hoping to get some help with. If you look at State versus Rogers, it doesn't say a thing about a separate showing prejudice. It says, quote, prejudice to a defendant is presumed when, quote, the likelihood that any lawyer, even a fully competent one, could provide ineffective assistance is remote.
Right. So I think
Therefore, prejudice is presumed because no one can be certain how trial counsel might have been able to perform if he'd had adequate time to prepare for trial.
if I can answer that on two levels, the first level being our primary argument that because diminished capacity was not an issue in the felony murder conviction where the underlying felony was a general intent crime, that there couldn't have been ineffective assistance of counsel there. But I think our second answer, Your Honors, would be that that standard doesn't apply because a competent attorney could have presented this defense. I think it's undisputed that defense counsel knew the state was interested in the calls many months beforehand, before the trial started. At record page 36 and 37, you can hear, or you can read the counsel discussing how at an earlier conference, an earlier hearing, the state informed the defense that they were looking into the phone calls. And of course, if the defendant thought that there was anything meaningful in those phone calls, they, just like the state, could have requested them from Global Tellink. But I mean, it is significant that the state told the defense on 23 April 2017, which is the day before jury selection begins, that they intended to use 23 of these phone calls as potential rebuttal evidence to a diminished capacity defense. And then they weren't used until 11 May 2017. So really, I think the key takeaway is that there was a total of 18 days, including 13 business days, between when the defense knew the state intended or might use some of these phone calls and when the evidence was actually presented. And I want to talk a little bit about the defense team because that came up in the dissent.
Before you go there, did defense counsel have the ability to rely upon the state's representation that there was no need to be concerned about those calls because the state was not going to use them?
I think I think that there was no problem in the defense relying on that. I mean, I would note, I don't have the page in the record for you, but there's an email saying, at this time, we don't believe that we're going to use these calls. So it was not, we will definitely not be using these calls at any point. So if your honors want to look at it just from, 23 April 2017, which is when the state informed the defendant that they would be using a small portion of these calls potentially as rebuttal evidence. I think that that's a fine time to start the timeline. But, given how big this defense team was, I mean, there's a lead attorney, a lead investigator, a jury consultant, 2 additional attorneys, and then if you want to count the mental health expert, Dr. Corvin, that counts a total of 7 people. And I would note that I forget his name, Mr. Friedman, was from the North Carolina Capital Defender's Office. So these aren't inexperienced trial counsel. And then when the objection or the request for a continuance is renewed right before the state introduces this evidence, this is at transcript page 2717 to 2719. Mr. Friedman, the lead attorney, says that he has listened to all of the calls, the 3.5 hours of calls, the 23 phone calls, and then he said that his lead investigator, Mr. McCaw, who I apologize to the gentleman because I'm sure I mispronounced his name, but Mr. McCaw had listened to every single phone call that the state had produced. That's specifically at page 2718. So to say, the defendant's submission that no competent attorney, even as in this case, a defense team of at least 6 people, could not have had time over the course of 18 days to listen to 3.5 hours of phone calls or the entire batch of phone calls is simply belied by the evidence, because they did in fact listen to those calls before they were used by the state. And our submission is that if there's anything useful in any of those other calls, that the defense team would have used them because they had an experienced investigator, which the lead counsel said, quote, understood what this case was about, unquote. Look at those calls and look to see if there's anything useful in them. And I would like to just quickly point your honors to State versus Searles, another case from this court, where your honor said that a trial court did not constitutionally err in denying a motion to continue to allow defense counsel to review evidence where the defendant failed to show on appeal what this evidence would show and how it would in fact be material. And there's been no pointing to any of the other phone calls to show that they were material, what they would have been, or how they would have impacted the case. And then to the 23 calls that were used, the defense counsel and the defendant had an expert mental health witness, Dr. Corvin, who was familiar with defendant and his conditions as far back as, I believe it's April 2015, but sometime in 2015, and who was already called as a witness for trial. There's no explanation about how over those 18 days, those 13 business days, the defendant or defense counsel, one of 3 attorneys, could have contacted Dr. Corvin and got his opinion on what this, how these potentially impacted the diminished capacity defense. And of course, I just want to keep it in your honor's mind, that's putting aside our argument that because diminished capacity is not available for a general intent crime, that's another reason why these were immaterial, at least as to that murder conviction and that life sentence. I would just finally like to, unless there are other further questions, I'd of course be happy to take. I just want to point out that the defense was given a chance to present surrebuttal after the state played these phone calls. So, the defense, makes some issue about this being the last thing that the jury heard. But they had a mental health expert witness available to them. They had 18 days to give him these phone calls and see what he thought about them. And they were given the chance at transcript page 2756 to present surrebuttal evidence, but declined to do so. So unless there are any further questions from the court, I'll simply end. Are there any? I'm sorry. Too quick.
Yeah, I do have one
Yes,
question.
Justice
I'm trying to understand that the argument that none of this diminished capacity defense is relevant to the underlying felony for the felony murder because it's a general intent crime. That was not argued by the state in the Court of Appeals, or am I right about that?
I believe that that's correct, Your Honor, but it did form the basis of the majority of the Court of Appeals opinion. They said that at least as to the diminished capacity as to that felony murder conviction. Of course, the Court of Appeals went on to determine whether there was any prejudice as to the armed robbery felony murder conviction. But unless I'm mistaken in my thinking here, that's formed part of the basis of the Court of Appeals decision in that case. So I think it's properly before Your Honors.
Okay, thank you.
Thank you. Unless there are any further questions, I would just urge this court to affirm the judgment of the Court of Appeals. Thank you.
Thank you, counsel. Rebuttal.
Marilyn, you're muted. Ms. Ozer, you're muted.
I'm sorry, someone muted me. Answering Justice Irvin, on page 73 of the record, the judgment for the robbery with a dangerous weapon is 60 to 84 months to be served consecutively. To go back to Mr. Dunn's argument, I think there's a discrepancy between what's counting 18 days and the real world. When you're in trial, a first-degree murder trial, you're in trial all day, trying to keep up with the witnesses, cross-examination, reviewing statements. When you go home at night, what you have to do is start reading all the statements you have for the witness for the next day, perhaps interview witnesses for the next day. You don't have any extra time. You don't have 5 minutes extra time because you're constantly in preparation for the state's next day's witnesses, and at the same time preparing for your rebuttal for your witnesses. So 18 days sounds like a lot of time, but in those 18 days, all you're doing is interviewing witnesses, going over statements, and doing what you have to do in every single trial. There was no defense team. This error appears throughout the state's briefs and the majority opinion. It was Steve Friedman by himself. At one point, a new attorney from the Capitol Defender's Office came and sat in the courtroom so that she could experience what a trial was like, but this wasn't her case. There was another attorney who came in sometimes to help with what was going on in the trial, but that involves going through the files and trying to find the statements that you need for that next witness, telling Mr. Friedman if there's some other question he should be asking. It's not that that attorney knows anything about this case in particular. The investigator in the case, as is brought up several times, comes down with pneumonia the week before the trial begins, and he's out for a week and a half. Another investigator in the office tries to fill in, but it's not her case either. And you have to remember, all of these attorneys have a desk full, file box full of cases they're working on. So this was Mr. Friedman by himself, at one point with a substitute investigator, and finally, and it's Richard McGuff. Mr. McGuff comes back in and helps. And maybe they were able to listen to the calls. I really doubt it was all 800 of the calls, because that would have been weeks worth of work. But there's more than listening to these kind of videotapes. What you have to do is listen, write down what you're hearing, go back, replay, write it down again, get the times. So even if the call actually takes 10 minutes, you're listening to that call for 30 minutes before you've got everything down. And then when you've finally done that, you have to get a hold of Dr. Corvin who is constantly in court, constantly seeing patients, and try to get him to find the time to listen to these calls. And in the real world, this just isn't possible. And the state, in its briefs before the court and this morning, suggests, well, they knew there were calls out there. Why weren't they listening to them anyway? Well, why on earth would Mr. Friedman be relying on jailhouse calls to show that Mr. Johnson was mentally ill and intellectually disabled when he had unimpeachable records from school, from community service groups, from the Durham County Jail, from Central Regional Hospital, that all showed that he was suffering from intellectual disability, bipolar, and other illnesses. You just wouldn't spend your time going through jailhouse calls, trying to find evidence that this client is mentally ill when you had all this unimpeachable evidence that doesn't carry the burden that using jailhouse calls carries. Because once you've introduced a jailhouse call, you know the state's going to say, okay, open the door. I'm playing all the other jailhouse calls. So in the real world, it doesn't make any sense to say that Mr. Friedman should have been looking at these calls a year before the trial, or even 2 weeks before the trial, when things that he had to do, like interviewing witnesses, had to take precedence. And that's what he did. Another thing that comes up in
This is just sort of a factual question. What's the time frame? Was it in between when the calls were recorded and when the offenses occurred? Was it close in time?
the calls that they used weren't really supposed to go to the offense. It was a month later. The incident occurred on July 4th, and Dr. Corvin saw Mr. Johnson on August 13th. So it's about 6 weeks. But
the calls were recorded when? Relative to those dates?
The calls that the state used were the day before Dr. Corvin interviewed Mr. Johnson, the day of the interview, and the day after. So the calls went to Dr. Corvin's interview, not so much to the incident itself.
Okay.
And that's what they said, that they were using them only to rebut Dr. Corvin.
Okay. Thank you.
Okay. And the other thing that appears in the majority opinion and this morning is a question about offer of proof. Why didn't we go through the rest of the 800 phone calls and show what the counsel could have done? Well, as this court knows, the offer of proof has to be done at the trial level. And you run into the same time constraint with an offer of proof as you did to give them to Dr. Corvin or anything else. He didn't have time to listen to all those phone calls. So the trial court was not shown an offer of proof. And on appeal, I can't go and listen to the 800 phone calls and say, listen, this is what they say, because the trial judge didn't hear them. So when this court is ruling on what the trial court did, the offer of proof had to be made at the trial court level, not at the appellate level. If this court doesn't have any further questions, I once again ask the court to follow Chief Judge Stroud's opinion and find that there was Chronic and Rogers error and that prejudice is presumed. Grant Mr. Johnson a new trial. Thank you very much.
Thank you, counsel. Madam Clerk.
Oh yes, oh yes, oh yes, the Supreme Court of North Carolina will be in recess for 15 minutes. God save the state and this honorable court.